al. Can counsel please announce their appearance, beginning with plaintiff's counsel?
Good morning, Your Honor. Karen Palasek on behalf of Clean Energy Services, CES LLC. And with me is Sarah Mills, senior paralegal in our office. And I am not seeing my client on there, but he was planning to join.
And counsel for defendant?
Thank you, Your Honor. Ryan Pont on behalf of Sunstreams Expansion LLC and Great Midwest Insurance Company. With me joining remotely is my client representative, Chloe Rosen.
Oh, Ms. Palasek, did you want to check to see if your client is able to join me? Also live stream, so they may be just watching it that way.
Okay. Do you mind if I take just a second to text him?
Not at all. I do need to finish on time because I have an 11 o'clock, but if you can jump on quickly, that would be fine.
Okay. I will do it right now. Thank you, Your Honor.
It looks like someone is trying to join. It is, who do we have just added to the line?
Hi, good morning. My name is Constantine Trantafilides. I'm with CES. I'm sorry, I was having some connection issues.
Oh, that's okay. I just wanted to make sure the person, you were the person we were waiting on. So welcome, everyone. We're here for oral argument on the pending defendant's motion to dismiss the claim for discharge of a lien bond, although it's really a motion to dismiss both claims. I've reviewed the complaint, the many exhibits to the complaint, the parties briefing, and the cases that were cited in the briefing. So I still end up interrupting sometimes, but in an effort to try to avoid interrupting you too much during your argument, I wanted to kind of give you some of my thoughts. Obviously, I also went through and reviewed the notice of supplemental authority and reviewed Judge Schreiner's opinion in the Sarampo case. So for the defendant, the problem you have with that case is that it agreed with your position on the licensing issue, but not on the unjust enrichment claim. And so for you, I think where I'd like for you to focus is how, when we're at the pleading stage, and I have to assume the truth of the allegations and draw reasonable inferences therefrom, I can find, contrary to what Judge Schreiner found, that there is no activity for which payment is sought that is not that is outside the scope of the licensing statute. Because under that standard, I'm struggling to say I could dismiss the unjust enrichment claim and find as a matter of law that there is no activity that is not that is out, so that falls outside the scope of the licensing statute. Under the Butch and Musa cases, which I also read, that the licensing statute is not a means to eliminate claims for unjust enrichment that fall outside the statutory scope. For you, Ms. Palaszczuk, I think the struggle is the licensing statute, because and my focus is on the lien itself and the amended lien. The language in describing the work performed falls within the definition of contractor under subsection A3B. And in looking at the exception, the material exception, I agree with Judge Schreiner. I don't see how CES falls within that, because it was not a furnisher, I should say, or materialman, and there's not a really clear argument as to how it falls within that exception to licensing. So if you can kind of focus your arguments on those issues, and of course anything else that you want to add to your briefing. I'll start with you, Mr. Pont, since this is your motion.
Thank you, Your Honor. And I will kind of take this a bit in reverse and focus initially on the unjust enrichment claim. And appreciate your time and your thoughts initially, and I think that helps focus this argument. But as to the unjust enrichment claim, we have to go based upon what the scope of the work is that CES not only put in their complaint, but in their pre-lien, their lien, and in the subcontract documents itself. Those are all good evidence and the best evidence, especially at this stage, Your Honor, where the pleadings are what you have to accept as true for the factual allegations that the work provided all falls within under the statute that requires CES to have a license. Under Arizona law 321153, if you do not have a license, a contractor cannot maintain an action in any court of the state for collection of compensation for the performance of any act in which a license is required by this chapter. And so if we take the plain language of what CES has put in all of their pleadings, then everything falls within the statute that prohibits them from maintaining an action in this court, Your Honor. Obviously, the allegations in the First Amendment complaint in the Serrano are slightly different than the complaint here. But for factual background, this is a situation which Howe and the GC did file for bankruptcy after payment. And so not before this court, but eventually maybe is the issue of can you be unjustly enriched if the owner is actually paid the GC and money's failed to flow down. So just based on the plain language, though, Your Honor, the statute is effective and precludes CES from maintaining the action here today. Beyond that, and I want to address some of the licensure stuff and the language so that it more edifies that first argument. We have in the complaint CES alleging it provides site project management and field technician services. In subcontract agreement, they agreed to provide project oversight services through a site manager who will be responsible for monitoring the work of Powen. They have site management and field technician services, including installation oversight and commissioning oversight, supervising the completion of punch list items, and enforcing all safety requirements and stopping work if any of those acts are deemed unsafe or violate project safety standards. Those are all classic contractor actions that require licensure. In the pre-lien and the lien, CES alleged that they supplied technical services, technical support, battery commissioning, project management, and overall site management. Again, as our motion to dismiss puts it, this is all something that requires contractor licenses, whether it be a B1 or a C11. These are all fall within the gambit of activities that are required to be licensed in the state of Arizona. And if without the license, they have no ability to maintain this action. What is particularly interesting about the position advanced by CES in this motion is they want this court to not accept their factual allegations and pleadings as true, even though that's the court reference. That is what is required to do today. They want the court to somehow look beyond the plain language of their own pleadings and their own judicial admissions and say, well, there's more to it than what we've explained, and therefore you have to deny the motion to dismiss. That's not true, Your Honor. The motion to dismiss should be granted here because of their own judicial admissions, their own pleadings, which from a factual standpoint, the court has to accept as true. It's a bit bizarre that they are running away from their own allegations, which I think is telling. In addition to some of these things, I want to address the exemption that was raised by CES, claiming that they don't actually have to be licensed because of the exemption under 32-1101, which says they're not a contractor, and under 32-1121. So 32-1101, CES just cherry picks one subsection of that statute. They don't actually look at subsection 3B, which puts them directly in the statute. It's a subcontractor consultant who represent that they are able to supervise or manage a construction project for the property owner's benefit. Even the admin code says, you know, a contractor is someone who supervises all or any part of the work and includes, quote, the management or direct or indirect supervision of any work performed. And I'm not going to repeat what the allegations in the subcontract or the scope of work in the subcontract are, but CES fits cleanly within that. To try to avoid the contractor definition and licensure requirement, they lean on 32-1121, and that only applies to 1, materialmans, 2, manufacturers, or 3, retailers that furnish finished products, materials, or articles of merchandise that does not install or attach such items. CES has not alleged that they are a materialman, a manufacturer, or retailer that's supplying finished products. The exemption doesn't apply Pima County Superior Court found that. We think the court here should apply the same logic, find that the statute doesn't apply to CES. And I'm not going to focus too much on some of the other arguments about the pre-lien notice. I think the court has honed in on really the big issues, which is CES required to be licensed? Unless the court wants to hear argument about some of these finer details, we'll just rest on the papers on those issues. But otherwise, I can save the rest of my time for rebuttal unless the court has any questions for me.
Thank you, Mr. Pott. Ms. Pelichek?
Thank you, Your Honor. And yes, thank you for that direction with regard to your thoughts. But Your Honor, the complaint should not be dismissed. And CES was not required to be licensed. And I will focus on that. The biggest issue with defendant's motion is that they are having you make inferences in their favor and not in CES's favor. And you have to do that in CES's favor. And there are construction terms that are general. They even cite Webster's dictionary, like the term project management is not limited to the construction industry. You have to think about what was done here. And this is very unique. It was novel technology. And Your Honor, Sarah could pull up that big picture for you if that would help. That's in our brief on page 4. Would you like to see it so I can kind of explain the facts, or would?
You can. I have everything up on my other screen here as well, but I also made her a presenter, so if she wants to share a screen with any presentation, that's fine too.
Yeah, I just wanted to, as I explain the details of the work, I thought it might be helpful because what you wanted me to focus on 321101A3B, which talks about a consultant on a construction project. So if you take a look at this, the construction project was actually McCarthy. They did the site work. We had nothing to do with the construction project. We did not construct, alter, or repair anything. These are the modular energy storage systems, and that what we were hired to do all took place within those